My husband is a green card holder and I'm on F1 visa in the US. If we get married and we want to file, the visa bulletin says it's current right
Yes,
now.
you file,
So
if you get married and you file right now, you can file to adjust your status. But you would have to do it before the end of September.
okay, and then second question would be, if I adjust my status, I wouldn't need to file for EAD under my OPT because I graduate in December.
Well, yeah, you would. Well, I would still file for an EAD under the adjustment because you should get a work permit based on the adjustment.
Okay, thank
All
you
right?
very
You're very
much.
welcome.
Sometimes in March last year, I filed for adjustment 1A-I-485 and I-130.
Right.
Unfortunately, when they scheduled the interview, I couldn't make it because I was terribly ill.
What was wrong? What
So,
was your illness?
I was having some typhoid and cough, and my chest pain. So I went to a hospital. So my lawyer said since I can't make the interview, I should get a medical report.
I'm gonna tell you. All right, they're not rescheduling your interview because you have a cough. You would have to have been admitted into a hospital for them to reschedule. So the fact that you just went to an emergency room and got treated and left.
I was at the hospital.
Were you admitted? Did they give you a room?
Yeah, they gave me a room, but I just was just like for some few hours.
Okay, so you were not admitted. You went to the emergency room. That's not getting admitted to a hospital. So you did.
Okay.
So let me just tell you. All right, unless you're admitted to a hospital, you're denied. You got to refile again, point blank.
Oh, okay. I got denied, and my lawyer said I should file
No.
290B.
No. If you were not admitted into a hospital, you have. If you do not get a room, do you understand the difference between an emergency room visit and getting admitted into a hospital? Because an emergency room visit, according to immigration, they're going to call bullshit on you. Okay? What you need, if you are truly sick, they would admit you into a hospital, then yes, you could appeal. But from what you're telling me, I know how immigration works. You could appeal this, and the appeal is going to take you years, and you're going to still be spinning your wheels and get nothing. You have to go to your interview when they schedule it. There's no rescheduling unless you're literally admitted because you have a heart attack. Okay? So you can appeal all you want. You're going to be denied forever. Got to refile again.
Okay.
And then show up to your interview this time.
Okay. Thank you. And my last question, my I-290, I already filed for motion to reconsider, but unfortunately, I-485 and 130 was denied. They just said closed.
Are you listening to what I'm saying to you?
Yes, I'm listening.
Refile.
Okay.
Period. End of story. You have to refile everything. You don't show up to your interview, you got to refile. That's basically it.
I'm from Jamaica. I have a bachelor's degree in nursing. I passed my NCLEX RN. I have an active visa screen. However, the issue is I'm not licensed in my own country. So I want to know if that is
no. As long as you have, as long as it's not licensed in Jamaica, it's licensed in America with the visa screen, the CGFNS visa screen, and you're fine. If you have a you have a CGFNS visa screen, you're fine.
Okay, all right. Okay, so for example, like if I go to the consular embassy and they ask me for my local license, would that be an issue?
No, you don't need it. You have a CGFNS visa screen. That's all you need.
Okay, thank you.
You're very welcome.
So my quick question, I have two questions to ask you, sir. Yeah. My quick is I filed for two of my kids 2 years ago.
Yes.
I had two visas and they are already in the United States. So I've applied for the 220 green card for one, but I haven't applied for the second one, but they are due for renewal. Do I have to get the green card, 2 years green card before I apply for the 751 or
No, as a conditional green card holder, you can file for your children.
Yes, no, what I'm saying is that I've already filed for them. My wife filed for them. They are here in America already.
Okay, so
they were issued 2 years visas. But my daughter, I've applied for a green card. I have a green card, but I haven't applied for my son's green card. But they are almost due for renewal for the I-751. Do I have to apply for his green card before I'm filing the 751? I don't need to.
You're talking about, because you say your son got a 2-year green card.
Yes, he got approved from Africa.
Okay,
but I haven't gotten the plastic.
You haven't gotten the plastic card, the physical card, and it's almost up. There's 2 years. Yes, you have to still have to file the I-751. That is the answer.
But do I have to apply for the plastic, or I don't need to?
No, just apply for the I-751,
Okay.
and they'll send an extension.
Okay. My second question is that my first child, I happen to have out of wedlock. So she went for an interview yesterday. Right. I haven't seen her for 13 years. She's 14 now. I haven't seen her. So they requested for passport photographs.
Who filed for her, you or your wife?
Yeah, my wife filed for her.
Okay, so
they requested for passport photograph of me and her, but we don't have any.
You don't need to, because if your wife is filing for her, all you need to do is prove that you have a biological relationship with her. If you were filing for her, not a stepmom, but you were filing for her, you would need to show a bona fide parent-child relationship, and they would have every right to ask for that. But because it's the mother filing, they don't have a right to ask for that, and you may want to have
But they did have it at the embassy.
So you may want to have a lawyer get involved.
Okay, so they asked me to. So can I just send them a letter explain that I don't have it?
I wouldn't know. I would have a lawyer get involved because they're asking for things that they're not required.
Okay. Thank you so very much.
Okay.
My first question is, I came here on F1 visa, but right now I'm out of status.
Right.
And, so I got married last month, and I'll be filing my paperwork soon. But my husband and I don't live in the same state for financial reasons. I live with his mom in Maryland. Would that be a problem?
Yes, I think you asked that question. I've heard this question before. The answer is yes. You have to live with. It's not your husband's filing for you to live with his mother. Your husband's filing to live with you. So the interview is not I live with his mom, so it's a real marriage. The interview is I live with my husband and it's a real marriage. That's what you need to do.
I also had a question for my brother. He came here on a J1 visa. He came here 4 years ago, and he already filed his paperwork, and he hasn't gone for the interview yet, but the wife wants a divorce now. Do you think there's anything you can do about that?
No, go to a marriage counselor and work it out. That's what I would do.
Okay, so if he gets the divorce, then he can't go through with the interview or anything?
Out of luck. He's SOL, and that doesn't mean statute of limitations.
I came to the United States on 2014 on an M1 visa. In 2015, I got married to a U.S. citizen.
Right.
2016, I applied for TPS. 2017, I got married to my current wife. And 2019, I annulled my first marriage.
Annulled?
Yes.
Okay. So now you got to. Why was there an annulment?
The day of the marriage, the next day, she left back to her state, and we got. All right. I would remarry your second wife, even though it's an annulment, just because immigration's probably going to ask for it anyway, and file with your second wife. Okay, so I have to remarry because
even though legally an annulment means the marriage never happened, it was void. So you can make the argument that I don't have to remarry again because it was a void marriage, but it was a voidable marriage, not a void marriage. There's a difference. Okay. Meaning that there was a legal marriage at the time you married your wife.
Yes.
Okay. Which is different than there was no legal marriage because maybe your first wife was married to 6 other men at the same time. Okay. That marriage was void from its inception. There's a void marriage from inception. You can get an annulment. And there's a voidable marriage, meaning we're going to void this marriage out, but it was a true marriage for some period of time. So me personally, I can feel very comfortable walking into immigration and saying, this is an annulled marriage. It never happened. So he's only married one time, and here it is. But I could totally see immigration saying, no, you're a bigamist. So to play it safe, I would marry a second time just to play it safe.
Well, the thing is, my family lawyer told me, no, you don't have to.
Legally correct. Technically and legally correct. I just think you're going to have a problem with immigration.
Okay.
That's my 2 cents on it. So it doesn't hurt to remarry again. People renew their vows all the time.
Yeah, but the question is, since as you said, it's void, it's like never happened.
Correct.
Should I disclose it from the beginning?
Yes.
It's not considered like I'm giving information that I don't have to give?
No, disclose it.
Okay. All right. Okay, thank you, Brett.
Okay.
My husband has asylum case pending for more than 5 years. They never called him for interview. So what should we do?
Your husband has a case for 5 years and never got called for an interview?
Never.
Okay.
Never.
Are you a U.S. citizen?
No, I'm not. I'm in the same case. So he filed for whole family.
Okay. Who sponsored your husband?
Yeah, my husband.
Wait a second. Who sponsored your husband? Why is your husband getting a green card? How is he getting a green card?
No, he's not. My question is, he filed for asylum.
Your husband filed for asylum and hasn't heard 5 years because they're in a last in, first out situation. Meaning that I know that because they're working backwards. They're not working forwards. So, for example, if I file for asylum today, I'm going to get an interview before your husband. And they work backwards. So, in other words, you would think the fairness would be I filed for asylum and the person waiting the longest would get the interview first, but they're working backwards. So the only thing you can do is if you have a good asylum claim to file a mandamus and force the government to interview him. Other than that, he could be waiting another 3, 4, 5 years for an interview.
Gee. So there's nothing we can do, right?
I didn't say that. I just said you can file a mandamus and force the government to give an interview. It's a lawsuit in federal court. Okay? You may want to hold on. You may want to have a consultation. Hold on one second.
When you file for spousal abuse, right?
Yes.
For the first 5 months, you would, like, if you have a lawyer, I'm saying maybe they would, like, okay, issue your work permit, then you could use the work permit, apply for social, and further on your driver's license when you go to DMV. Mm-hmm. Right. Is it, all right, so in order to get so this is self-petition then. So in order to get your green card, is it going to be like 7 more months added on to that, or it's going to turn into 18 months? Like a whole year by itself, 12 months to get an interview for a green card? Or it's going to be added 5 months to the 7? That's, you understand?
I'm a little confused on what you're asking. After you get your abuse case approved,
mm-hmm.
Did you file an adjustment or you just filed an I-360?
No. I haven't filed anything. I'm just asking a question how it works.
The answer is you file an adjustment with an abuse case, and you'll get a work permit in about 6 months, and in 18 months or so from the time you file, you would get an interview.
So it's 18 months.
Approximately.
Okay.
All right, now, if you're going to file an abuse case, you better do it before the end of the month because I don't know if there's going to be an extension on VAWA.
Oh, okay.
All right, so you may want to do that.
So I've been in the U.S. since the age of 4. You know, my dad was my original petitioner. Our lawyer kind of messed up. He applied for my parents, but not me. I came on a B2 visa with my mother.
Uh-huh. Where are you originally from?
Basically, when I was in high school, we moved from Massachusetts down to Florida, and I was in high school, and I found out they're like, you have no status. So he applied for the I-130 at that time. It got approved. And then basically he passed away when I was 21. Basically at that time I had to reapply under my mother's name. And I did, I got her I-130 approved as well. And then I went to my green card interview and got denied.
Why?
Because I had some withheld adjudication charges. And I was deported in 2011 with withholding of removal. So I heard on your show that you talk about the 212 waiver.
Right.
And I was wondering, do I physically have to leave, or is there a way that I could apply for that while I'm still here, or, you know,
no, you would have
is there any sort of relief for me? You know, I've been here my whole life.
Well, I don't know what.
I'm 38 now.
The relief would be to try to vacate your convictions.
Would that actually affect it? Get those vacated?
Yeah, because you just told me that you have some convictions that got you denied. Is that correct?
Yeah, there were 3 misdemeanor marijuana withheld adjudication and 1 felony withheld adjudication, which were explained to me at the time. Adjudication withheld means no judgment made. You're not innocent, you're not guilty, you're neither nor.
Right.
And it wasn't explained to me on the federal level that this is considered a conviction.
Considered a conviction, correct. So you're
barred. I feel like I was improperly represented in all those cases because I would have fought them to the T.
It's very possible. But this all happens in Florida?
Yeah.
Okay, so yeah.
And it was the latest case closed in 2007.
Okay.
So it's been like 13 years almost, and I was deported in 2011.
Right, but
I've been getting my EAD every year and 3 months of not being able to work. My mother's a cancer patient. It's crazy, you know?
So where are you from originally, by the way, Adam?
I was born in Syria.
In Syria, okay. So
which is crazy. That's how I got my withholding of removal. I've been here since the age of 4.
So my answer to you is, it's like, you know, you call me up and you say, you know, sometimes the answer is like being a cancer doctor. Let me put it to you this way, okay? Patient comes in, they have cancer. What does the doctor do? You got to eliminate, got to operate and take the tumor out, okay? So what's causing you a problem? These convictions. You got to get rid of them.
Yeah.
It's like the tumor, you know, in a cancer patient. So it's not an immigration lawyer you need. You need to search out the best criminal defense attorney.
But I could apply for that 212C or what?
No,
because I'm already deported. I got just a judge's order withholding.
Right.
My removal.
You can conceivably, you would have to reopen your deportation case, but you would have to apply for the 212C waiver outside of the United States of America. My advice, because you never had a green card, my advice, all right, my advice would be, because a 212C you can get if the convictions happened before 1996 and you have a green card, or you can get a 212C waiver if you have physically left the United States and want to re-enter. But you've never physically left the United States, so you can't.
No, never. Since the age of 4.
So what you need to do is find the best criminal defense attorney that your money can buy in Florida and see if you can get your convictions vacated. If you can, then you can come back to see me and I can reopen your deportation case and get your green card. But other than that, you're going to be out of luck.
Even though it's been like since 2011, from my understanding, there's like cutoff lines so you could reopen them. But
there is, for cases that were before 2011, there's no constitutional mandate that the case has to be reopened because you had bad advice. But it's still discretionary on a judge's, you know, case by case basis whether that judge particularly wants to reopen your case and say this is an unfair event. Okay? So in other words, your criminal defense attorney for cases that were before 2011, the Supreme Court decision, because it only became a new right that you had to be told you get deported if you found guilty. It's a new right. Not
I would think, you know, under the Constitution or something, you know, I'd know a definitive outcome of accepting a plea, you know, like repercussions. But I guess not. There's some holes in the law.
Can I finish, please? Okay. So.
Yeah, sorry about that.
Okay, so just listen. If your convictions after 2011, this is what the Supreme Court says, it's a new right. The government has to tell you you're going to get deported. The prosecutor has to tell you you're going to get deported. The judge has to tell you you're going to get deported before you take a plea. Before 2011, there was no right to that. Whether you knew it or not, that's what the Supreme Court says. Whether that's right or wrong, that's wrong. How do you have a right to know in 2012, but in 2010 you don't? It doesn't make any sense. Okay? But that's what the Supreme Court said. Yeah. So, I'll tell you what we do in my office here in New York. I can't do it for you in Florida because I'm not a criminal defense attorney in Florida. Is for the cases that were before the Supreme Court decision in 2011, which is what your case is, okay? You work on the judge's sympathy, okay? Because it's a discretionary decision on a judge whether to reopen a case. A judge could reopen a case for any reason he or she wants.
Wait, so I'd have to reach out to each one of those judges in those cases.
You would need to get a good criminal defense attorney to file a motion based on all the sympathetic factors why this is an unfair result for you. However, the judge has a discretion whether to open the case or not. That's up to that particular judge. If your conviction was 2014, there's no discretion. The law says that you had to be told, and you weren't. But there's a difference. So after 2011, no discretion. Before, discretion. So you just need a good criminal defense attorney to when Leonardo DiCaprio was drowning in the Titanic and everybody's crying. You need a criminal defense attorney to get that emotion from a judge to reopen your case. You understand?
Okay.
All right.
Thank you so much, Brad.
You're welcome.
I really appreciate everything. I love your show, man.
Thank you very much.
As for a family member, I'm trying to help her. She's a citizen. She's going to petition for her husband, but she's getting Medicaid. Wait, I think she has 2 kids. Program for school.
Okay. If that's going to be your petitioner, she got to get the kids off. She can't take any sort of Medicaid, but she should file before October 15th for you because it's going to get much tougher after October 15th.
But she can still receive the Medicaid and the WIC thing, or she has to quit that?
If it's for her children, yes. If it's for her, she's got to quit it.
She has to quit herself and the children can stay on leave.
Correct.
Okay, and before that...
Assuming you file before October 15th. After October 15th...
Before.
Right. After October 15th, everyone's got to get off.
Okay, so the children can be on Medicaid, but she has to leave Medicaid.
Correct. She can't accept anything.
Okay, and I have another quick question. It's a person who applies her father being a resident when she was 20, but then she turned 21, and he became a citizen now, but the thing is she still qualify as two, the category for under 21?
No, she would be, she's over 21, she would be in the F1 category now.
So she has to wait, right?
Yeah.
And after her turn, is she going to be able to get a document, or she has to leave?
I don't know what her situation is. Is she out of status? Is she 245I eligible? I don't know that situation. And
she applied for a 130.
I know.
130 when she was 20.
Okay, I understand that. None of those facts help me to determine whether or not she has to leave or not. What would determine whether she has to leave or not is how her father got a green card, how the mother got a green card. There's something called grandfathering under 245I. Was she a derivative of an old case? All of that, I don't know. In addition, if she does leave, she would have to leave with a provisional waiver. She just can't leave. Because if she leaves without a provisional waiver, she'll have a 10-year bar. None of this she knows, and I don't have enough information to tell you whether or not she can get a green card here. But we can have a consultation and I can figure it out.
Yeah, I can tell her to call you guys.
Yes, all right?
Okay, thank you so much.
Appreciate it.
Okay.
I have a couple of questions. My first question is about public charge. So far as I heard, the new rule is going to start from the October 15.
Right.
So I'm a U.S. citizen, and I want to apply for my mom. So she's in Bangladesh.
Right.
So, and
you're going to fall under the new rule because you're not going to submit an affidavit of support for another year.
So if the rule goes effect, then I will fall in the rule, right?
Correct.
Okay, so my second question is, my wife has a green card. She's living with me here for last 2 years. And, so is this rule going to affect her to apply for the citizenship passport or no?
No, will not affect her.
So she can continue having the medical benefit or?
Yeah, whatever she wants. It only affects people who are applying to get green cards. It doesn't affect people who already have green cards.
So I cannot apply for my mom right now, right?
You can apply for your mom if you want to. Are you a citizen or a resident?
I have a U.S. passport.
Okay, yeah, apply for your mom right now today.
But you said the public charge is going to be applied for her also?
Yeah, you worry about it a year from now. Who knows what the rules will be? It could change. There could be lawsuits. Put it in I-130 for your mom.
I have the last question. My brother is 27 years old, and he is trying to get a student visa from Bangladesh to USA, and hopefully he will get it, So, yeah, if I apply for him, is my application going to harm, he's seeking for the student visa? Or?
Yes, it will, because it's going to show he has an immigrant intent. So you can't apply for a green card for somebody and then let them try to get a student visa. It will be denied.
Okay, so but when he applied, there is a, in the application there is a form,
Did you apply excuse me, did you apply for your brother?
No, not yet.
So then don't do it and let him apply for the student visa. And then on the form where it says, have you ever applied for an immigrant visa? The answer is no, he never did.
Okay, so if he had to answer, if someone relatives, lives in the USA, so he has to...
Tell the truth.
What's that?
Tell the truth.
Okay, so is this, this thing is not going to, harm his application, right?
Which thing? I don't even know which thing we're talking about anymore.
If he, said that, his brother, that means, I myself live in USA.
This is what will affect his application. Lying affects his application. That's number one. So lying, not telling the truth. When it asks, do you have relatives in the United States, and you don't tell the truth and they find out you're not telling the truth, you're not getting a visa. So by all means, tell the truth. That's number one. Number two, whether he has a brother in America or not is not as important as proving that he has enough reason to leave the United States when his student visa is up. That's what he needs to do.
Okay.
All right?
So, thank you, sir. Thank you very much.
You're very welcome. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.